Chair Fine, Honorable Board, we also received a response to your concerns about the 30-day notice for CPC 093-17. The Chief wrote a letter stating that it is important for the Board to understand the process, and when he considers imposing discipline on an affected employee. 1, there's the chain of command review. 2, there's Laudermill meeting scheduled with the affected employee. 3, there's a pre-disciplinary hearing conducted. And 4, final case review and employee notified of the final decision. The Chief says that these steps are rooted in departmental policy, city rules, and fundamental labor law, and make it virtually impossible for him to respond within the time frame called for in the ordinance. He has alerted city legal regarding this problem and is undertaking some revisions or consideration of revisions to the ordinance.
There's some points that need to be clear about this. First of all, the numbers always make me feel like we're not being transparent. So this is a case that we talked about in which it related to the Victoria Martens case. Our findings were that the detective and that the PIO both purposely lied in terms of information that they shared with the Journal and with others, and we felt that there should be certain discipline that was that went along with that finding. And the Chief has, by rules, has the 30 days to respond in writing to that. That 30 days came and went, and we hadn't heard. So we wrote a letter, I wrote a letter to the Chief asking what's going on, and this is his response. My point, and the point I made with Major Tyler, was even if you're not done, you owe me a letter in 30 days to tell me you're not done and why you're not done. That at least deals with the ordinance, and that at least, in my book, is good manners. So that was my concern. I don't know that what worries me about this letter is first of all, the first thing is there must have been a discipline that the Chief recommended for which the employee is complaining or asking for review. So that concerns me because he's come to a conclusion. He could have told us what that is. There may be other things that happen subsequently, but he could have answered our question. So he didn't do that. He didn't contact us. So those two things bother me. And then the other thing that bothers me is how many cases does this affect? You know, if there's discipline imposed and any employee that wants to can file a grievance and say that it needs to be appealed, does that effectively do away with our 30-day response, which is a community response? Responding to us is responding to the community. So those are the things that bother me about this, and I'd like you to speak to that, Mr. Martens.
Chair Fine, I have other supplemental information.
Okay.
I received the file yesterday, the case file, the investigative file, on return from the command review and return from Internal Affairs. On the 9th of September, the Chief entered a recommendation which states, I concur with the review and recommendation of Acting Major Collins. Policy violation 1-1 4B7A is sustained. In review, this violation is a Class 5/6 sanction. Chart of sanctions is an 8 to 32-hour suspension, PDH, preliminary discipline hearing, to determine the final. That's signed by the Chief on the 9th of September. He addressed your concerns in the letter on the 4th of October. So he bases his decision on Acting Major Collins' memorandum, which I have for you here if you'd like me to go through it.
Yes, please.
After reviewing the case in its entirety, I find that while I concur with the investigator that a preponderance of the evidence shows that an SOP violation of 1-1-4B7A occurred, when Officer D provided incorrect information to Albuquerque Journal reporter Ms. Elise Kaplan in January of 2017. I do not concur with the investigator's findings that a preponderance of the evidence shows that Officer D intentionally lied or was untruthful. I recognize the standard of preponderance amounts to more likely than not that a violation occurred, but giving incorrect information and lying are two entirely different matters and are not interchangeable. Lying requires intent, and based on information provided, I do not believe this factual allegation can be sustained. Ultimately, after reviewing the facts of the case, I believe there is a preponderance of evidence that inaccurate information was provided to the media by Officer D, of which he had a duty as the PIO to assure was correct. Therefore, he failed to successfully perform his duties as PIO. The investigator makes the findings that Officer D intentionally lied, unquote, based upon a number of facts that I do not believe are sufficient to reach this conclusion. They are detailed as follows. There were no recorded, compelled interviews of the CACU sergeant or division commander. Instead, there were only telephonic conversations, not recorded, with both of them, and the information received was constructed in the investigation based on notes and memory of the investigator without a compelled recorded statement from the sergeant or the commander. I am unable to assess how the information obtained by the investigator is sufficient to show that Officer D was intentionally untruthful. Even if I were to consider such statements as described by the investigator's memory, they are not sufficient to reach the conclusion that Officer D intentionally provided false information to Ms. Kaplan. According to the investigator's notes and memory, the conversation showed that Officer D had been provided information that no officers went to the Martens' home to look into the alleged kiss. Officer D's compelled recorded statement, he states he does not recall what information was provided by the sergeant and the commander. He states that when he spoke to Ms. Kaplan, he provided the information he believed was accurate and true at the time. This evidence does not substantiate the allegations of untruthfulness. Rather, I believe that Officer D's actions were a failure to adequately perform his job duties. It was his duty as the PIO to verify with the sergeant and the commander what occurred. Parent, if he could not recall what information they in fact provided, parent, to review and understand the CYFD summary prior, emphasis added, to his meeting with Ms. Kaplan. He failed to do so, and this resulted in the provision of incorrect information to Ms. Kaplan. While I recommend that an SOP violation of 1-1-4B7A be sustained, I do so solely on the evidence within the record. Officer D had a duty as a PIO to assure that any information provided to the press and public was accurate and correct. He failed to do so and was ill-prepared for the interview with Ms. Kaplan. A violation regarding untruthfulness should not have been addressed by SOP 14-4, which states personnel will not alter, misrepresent, or make any false statement in any report, verbal or written document that has been completed in the course of their employment. While this SOP may be added to the list of charges, I would recommend a finding of not sustained. There are supplemental issues obvious in the investigation which such a lack of knowledge by Officer D of the Fourth Amendment. This is an issue that could be resolved with training at the academy. Therefore, I am recommending that Officer D receive training on the subject matter. Regarding Director E, I also recommend an SOP violation of 1-1-4B7 be sustained, and I do so based solely on the evidence within the record. It appears Director E was working off of the information provided to her by Officer D. However, there was significant delay in correcting the information to the journal. When I reviewed, we did not allege untruthfulness as it relates to reports, the 1-4-4, because we believe that that's solely constricted to police reporting and report writing, not information provided to the media. So therefore, we did not even bring that forward to the board. Our investigation and what we believe supports the untruthfulness was the record to sustain under the violation that we both agree, while for different reasons, should be sustained. I made my recommendation for discipline for the 80 hours based upon the fact that Officer D has a previous level 6 sanction in 2016, and therefore by the matrix that makes that a first sanction level 4, and that's why I made the recommendation for the 80 hours. At this point, waiting for the pre-disciplinary hearing findings, the chief is recommending an 8-hour suspension.
Say that one more time. The who recommended?
The chief is recommending an 8-hour suspension.
For Officer D?
Correct. And a written reprimand for Director E.
Okay. So that letter was written on September 9th? Is that report was written on September 9th? Is that right?
Chair Fine, that's correct. This is signed by the chief on the 9th of September. Acting Major Collins' memo and findings were on the 8th of September, and the letter to you
is a month later,
which you sent on September 29th. Your letter on September 29th, to which he responded on October 4th.
So what was the delay? If they had that assessment, why was it so long, a month, between their decision and their assessment of the situation and our getting a letter? Why was there that gap?
Chair Fine, I can't answer that question.
Lieutenant Garcia, do you know?
Chair Fine, I was not here at that time. I cannot answer that question directly. I can speak to our process, and our process is that we do not release recommendations. We only release final discipline. At this time, there was a predetermination hearing to be held with the chief that was scheduled, and therefore we did not have final discipline until this week.
So it was the review process by the employee, the request for a review, or what?
Chair Fine, so it was the request for a hearing by the employee with the chief. The employee is given a letter once the chief does make their recommendation, and then they have a right to meet with the chief to present additional facts or their side of the story, any information that they would like to offer beyond the investigation. After that meeting, the chief will send Internal Affairs his final decision for discipline, and that's what happened in this case.
So they're appealing the 8 hours suspension and the letter of reprimand, and that's what the delay was due to, was their appealing of that.
Chair Fine, it wasn't an appeal, it was just the opportunity to be heard by the chief. It was recommended discipline, therefore there was not an appeal. An appeal would come after the final discipline.
Okay. Mr. Harness, what do you think of that time gap?
Chair Fine, it appears that there is some internal policy within APD for them to not release a recommendation. But I don't know why, if the ordinance states that the chief is supposed to inform you what his recommendation is, why the chief simply can't do that. The board understands that there are other processes that could come into play as far as the final discipline, but
there's no reason in your mind.
I mean, there was the chief had reached a conclusion on the 9th of September, and I think that conclusion could have been shared with the board if
within the 30 days.
Within the 30 days.
Yeah, seems that way to me too.
So
what do we do with this is my question, because it not only was there a delay, but now it seems a circumvention the process, of the 30-day process. So, how do we prevent this from happening again? How do we maintain the integrity of the 30 days? It seems to me that we need to communicate this with the City Council and the Monitor and the Department of Justice to make sure that all the parties understand that what is set as rules is not being abided by. So we can't just roll over and take it. I mean, we have to tell whoever is in charge of this process beyond us that this is not acceptable. At least that's my opinion. What do y'all think? Anybody have any comments you want to add?
Well, I guess I would put a little bit different spin on it, in that it isn't a matter of preventing something from happening again, but it's getting something to happen that is supposed to happen according to the process. And I think that makes it a little bit more difficult to correct, because it requires an action on their part to make this happen instead of just stopping doing something that they were doing. So I don't think that, gives us any path forward, but I think it just indicates that it's a little bit more difficult question than getting them to stop doing something or preventing it from happening again.
So what's your recommendation on where we should go from here?
I think we ought to inform the council and the DOJ both. So,
and the Monitor.
And the Monitor, yes.
Okay. St. John, do you have a thought?
No, I just agree that we need to notify them.
Okay. Dr. Brown?
I'm really sort of stuck on the discrepancy between Mr. Harness's recommendations and the police. To me, that's the big issue, so that's where my brain is. I'm sorry.
Well, your point is well taken. There's a big difference in assessing the facts between one and the other. So we have, this is a great example of a non-concurrence.
Right.
So what do we do with that?
Yeah, I know we're talking about this right now, but frankly, that's where my brain is. So whatever other people think is fine with me, but that's what.
Mr. Armijo.
That's not the big issue for me.
I agree. I think we need to take it to up the chain, if you will, and get some answers. The discrepancy from what Mr. Harness talked about to 8 hours is huge. And I know that the chief is the chief, but there's still some processes in there that don't quite make sense.
Mr. Waits.
Well, I'm kind of stuck on the same thing as Dr. Brown. When we look at discipline and look at those type of things, there's an issue there. On the other side of the coin, he did respond to us, but not in a timely fashion. That's understood too, and that's a step forward because we haven't gotten that in the past. But like Dr. Brown said, I'm stuck on that discipline part of it. So I'll go with whatever the board thinks. No problem.
I'm going to, excuse me, Director Harness.
Chair Fine, I mean, this is going to be reviewed by the Monitor because it is a non-concurrence, so every non-concurrence will be reviewed. The issue with the chief complying with the ordinance, my position is that the way it is now, there was non-compliance. I don't believe that I don't believe the process is harmed, however, if the 30-day notice comes after there's been the entire process for the employee. Because anytime there's a discipline recommendation, it has to go through that process. And so if the ordinance was to change to say 30 days after a final disciplinary decision, I think then the board, I think you're then there in the same place, right. As opposed to the chief having to say, well, right now I've made this recommendation, but I still have to go through these processes, which the employees are entitled to, and those aren't going to change. And I think the board would be better served to get the final letter to say, we went through this process, we had the predisciplinary hearing, we had this, and based upon all of this, I've reached this conclusion. And then that should be the report that would come to the board. But as the ordinance currently stands, there is, there clearly wasn't proper notice.
But here's my concern. First of all, we have some reply requirements, which I think are appropriate in terms of replying to us. I understand what you're saying, but I would prefer to say that there's two ways to do that. There's the way you've just said, and another way to do that would be to say, after 30 days, this is what I recommended, but we are going through these processes. And I will let you know what the final result is, and at the time of the final result, he lets us know what happened. But he had a recommendation in time. That recommendation is being appealed. That's still a recommendation on his part. So to my way of thinking, he could have done that in the 30 days and should be able to do it in the 30 days, and then whatever happens down the road happens down the road. And then we find out there was a change. But to my way of thinking, he made the decision within 30 days. He may alter that decision based on what happened subsequently, but he made a decision and didn't tell us about it. So.
Yeah, Chair Fine, I agree. I think we have to be careful then, and as Lieutenant Garcia pointed out, this isn't an appeal. This is the process for discipline. So it's not an appeal. This is them having their day in court, essentially.
So does this always happen?
Yes, this is a part of every discipline recommendation. If the employee chooses to use the process, then this is the process that they have available to them. So this is not an appeal. This is part of the process to reach a conclusion. The appeal is a whole separate process. So this is the decision process that every employee has the right to at this point. So so we have to be careful with that distinction. However, absolutely, the way the ordinance is written now, yes, there was a duty, and that duty wasn't met.
I have a question, and maybe APD answer this, but what's the length of time that each of these processes take? I mean, from APD's standpoint, the initial process and the appeal process. I'm just curious how this fits with the time scale.
So there's no specific, I'm sorry, Chair Fine, Dr. Cass, there's no specific timeline of when the PDH has to occur. The employee has to be notified in writing within 14 days of the chief's decision, their recommended discipline. However, as soon as the employee is notified, they can request the PDH from the chief, and the chief will schedule it. He tries to do it fairly quickly because it's not really fair to hold the employee in limbo. However, sometimes things do come up and they may have to be rescheduled, or his schedule isn't conducive to a very quick PDH. It's generally done within 30 days, though.
But there's no limit to the length of time that the chief can take to schedule the hearing, is that correct? Or schedule the interview?
That is correct.
But his assessment of the facts still takes place within that 14 days. Isn't that right? Didn't you just say that?
So, Chair Fine, the 14 days is once he makes his recommendation, the department has 14 days to notify the employee of the proposed discipline.
How much time does the chief have to make his recommendation on discipline?
The entire chain of command has 30 days to review the case and propose discipline. There's no set time limit on when that discipline has to be final.
Okay, so in 30 days they have to come to an assessment of the facts. Is that correct?
Chair Fine, that is correct. Yes.
Okay, so in 30 days we ought to be able to have that. We ought to be able to get that. An assessment of the facts. We assess the facts, y'all assess the facts, and we compare it. The people we're not talking about is the public, okay? And that's the problem to me, not this board. We represent the public, but we're not the public. And the media is looking for an answer once the assessment of facts has happened. So to my way of thinking, what the process is after that, because of merit rules or HR rules or whatever that is, doesn't negate the bottom line, which is what did you discover from this and what did we discover from this? looking at the same set of facts. And that's the problem I have with waiting. So I think I've been as clear as I can be about that. How do you want to proceed? Do you want, just in terms of responding to this letter, do you want to have this go to policy and make a recommendation for how this should be addressed, or do you just want to do a letter from me, or somebody help me out here? Mr. Jackson, do you have any thoughts?
Chair Fine, there are a number of ways to proceed here. One way would be follow up with an additional letter. I note that the letter that was received or that was sent on October 4th doesn't discuss in any way the chief's recommendation. This is something that also could be referred to the policy committee to see if there's a way to work within the timelines that APD has for imposing the discipline. Although, given that there is no set time for the predetermination hearing, I'm not sure how fruitful that would be. I also note that if an officer is perhaps nearing retirement, they may simply postpone, and retire, and then the predetermination hearing never takes place. It's also something that we may raise in conjunction with the response to the other letter and discussions with the city attorney. Those are all courses of action that are available to the board here.
I'm looking for recommendations from the board members. Which way do you want to go?
I guess at this time, it seems that the most immediate thing we could do is just inform the interested parties or potentially interested parties and keep pushing on this. I mean, I think this, in my mind, it comes under the category of the general response that the public gets when a case is being investigated, and we can't tell you anything about it until the investigation is over, which includes when the investigation is going to be over. So things go on without anyone's knowledge, and pretty soon it sort of drops out of sight. And this is what I'm afraid is happening here. And I think it's worth addressing because I think it's a general problem, and not just in these kinds of cases, but in the general case of investigations that the public has a right to know about. And delays are the way to keep it from being brought to the public's attention. So I think just doing what we can at this time is to write a letter. But
Do you think policy should take it? Or no? I just want to know.
Well, I mean, we can certainly consider this. I'd like to hear more information about. I'd like to become more familiar with this before.
Okay. So maybe one of the paths we could take is for you in your conversation with our attorney and Mr. Schmiel to be able to discuss this as part of that conversation and come back to us with some information, and then we can decide whether or not it goes to policy. Does that work?
Yeah.
What are we going to say?
No, I agree. I think a letter is appropriate right now, so I'm in concurrence with that. So.
Okay.
Chair Fine, I think one of the basic questions answering Attorney Jackson's concerns is exactly where is the predisciplinary hearing covered in policy within APD for establishing those timelines and having the policy subcommittee examine that policy and make a recommendation for the timing of that? Or is it something that comes under the collective bargaining agreement where this body would not have any ability to affect that policy? So we have to, I think that's the basic question first, where does this predisciplinary hearing come from? What's the origin? What's the policy? Where does it come from? And how would, in fact, the subcommittee examine that?
So your recommendation is that we investigate that, the staff investigate that, the committee investigate that, what?
Well, Chair Fine, I think that that's the starting point well, I think the policy subcommittee would have to examine the entire discipline process to include requirements from HR that are outside of APD policy, and then what's within APD policy that the board can make recommendations. And secondarily, the oversight ordinance is still in a phase where other amendments and proposals could be added because it has not been before any subcommittee of City Council. And so there's the option of
Well, we've already
looking
agreed
at-
that we're going to make sure the city council
looking at the
knows about
ordinance.
this as it relates to the ordinance. We would have to include that in the letter we're writing anyway, right?
Certainly.
Okay.
And to my way of thinking, the union has to be involved in this conversation, doesn't it? For the predisciplinary hearing, I would assume that's part of this union agreement is.
Well, it doesn't necessarily include us with the union, but we have a conversation and they should have a conversation. It isn't necessarily the same conversation. So I don't know that I want to open up that bailiwick because I don't want to be dependent on that conversation for us. You know what I mean?
So
We're not tied to that as much as they are.
one other question, and that is, what's the SOP that covers this? And you, as you said, there's a human resource policy as well that covers it outside the SOPs, right? So do we know what the APD SOP is that deals with this?
Chair Fine, Board Member Dr. Cass, some of it is going to be city HR, and then I believe Lieutenant Garcia is getting information that the predisciplinary hearing is actually part of the collective bargaining agreement and not an SOP, not an APD policy.
In order to unravel this, and this we're just talking about process questions, I think it would be good for the staff to research what policies the committee should take a look at, send them to Dr. Cass, and he can figure out how his committee is going to address that, and then decide whether or not he wants to participate in those conversations with Mr. Smealy and our lawyer and you, and do it that way. Content-wise, which is I think what Leonard and Dr. Brown were both talking about, is that we are at non-concurrence, okay? And what happens with non-concurrence, just so everybody understands, is that we present all of those cases to the monitor and the Department of Justice. We also present it to the City Council, so that we have done our due diligence, the department has done what they believe is their due diligence, and that is there to be compared by the powers that be beyond us. We have reached, content-wise on this case, we have reached our limit. And the next recourse is policy change. And that is not the process, it's not the content. It is the process, not the content. Does that make sense?
Yep.
Okay. Are we ready to move on? Okay.